Many business tenants are still struggling to pay rents due against their properties, incurred during the period of lockdown in 2020 and 2021. Similarly, landlords are struggling to recover rents for property and services provided to their tenants. Lawmakers are working hard to provide a structure around this ongoing problem. On 9th of November 2021, the government published a new code of practice for commercial property relationships following the COVID-19 pandemic, and the Commercial Rent Coronavirus Bill was introduced to the House of Commons. The aim of the bill, which is expected to pass in March, is to provide an arbitration backstop for when landlords and tenants are unable to reach agreement on how to deal with rent arrears that have accrued during periods of enforced closure. The bill will provide a 6-month breathing space and extend restrictions on enforcement action by landlords, during which a compromise agreement can hopefully be reached or binding arbitration can be invoked. During this protected period, tenants who are unable to pay their rent on commercial premises due to debt or cash flow issues caused by coronavirus should attempt to reach a settlement agreement with their landlords. If they fail to do so, the parties can join an arbitration process and therein avoid court action for recovery or potential forfeiture. There are, of course, some conditions here. The bill creates the concept of protected rent debt, which considers qualifying rent to be protected if the tenancy was adversely affected by forced closure requirements due to the coronavirus regulations during the protected period. In England, the protected period runs from 21st of March 2020 and ended on or before 18th of July 2021, depending on the specific closure requirements. What is meant by qualifying rent? Well, aside from the obvious headline amount due for use of the property, rent also includes VAT, interest on unpaid amounts, and service charge, which in turn often includes insurance charges. However, the bill considers rent that has already been paid, rent arrears incurred before or after the protected period, and any rent arrears incurred by tenants whose businesses were not forced to close to be unprotected rents. Landlords will be able to exercise their usual remedies in all of these cases. A key point is the new restrictions on the use of rent deposits. Over the last few years, we've seen lots of examples of tenant and landlord clients negotiating complicated arrangements over the pull-down of rent deposit sums in lieu of rent payment. Now previously, failure to make good a rent deposit was considered a breach of the lease and ran the risk of an application for forfeiture. That all temporarily comes to an end under this bill, as deposit funds pulled down and not topped back up are now essentially considered to simply replace unpaid rent and hence have the protection of the moratorium. Tenants and landlords will both need to factor that change into their considerations. If a settlement cannot be reached and arbitration is invoked, what does that ultimately mean, and what will the arbitrator consider? Well, the arbitrator will decide whether the tenant should receive relief from payment of the protected rent debt, striking a balance between preserving the viability of the tenant's business whilst preserving the landlord's solvency on the other hand. It's likely that a repayment plan for a proportion of the unpaid rent with a balance written off will be the outcome in most cases, but that will vary depending on the relevant circumstances. All in all, the situation here is complicated, and landlords and tenants looking to negotiate a solution to unpaid rents should be taught to take detailed legal advice on the rules and restrictions in place and the available routes forward. We're certainly finding that clients appreciate expert help in navigating the options available to them as the financial impact of COVID-19 continues to play out.